Good afternoon, I should say. Everybody have a seat, please. Welcome back. I trust you all had a very nice weekend. You ready to get to work? All right. Now, before we get started, I want to introduce everyone to you since it's been since Thursday since we saw each other. My name is John Kastrenakis. I'm your judge. Ms. Breanne Briggs is our deputy clerk. Ms. Catucci is our court reporter, Susan Catucci. Deputy Pat Ross is your lifeline to me. If you need anything, Deputy Ross is there for you. On behalf of the people of the state of Florida, we have Ms. Emily Walters and Mr. John Cardiello. And on behalf of Mr. Scandirito, the accused citizen in this case, we have Ms. Elizabeth Ramsey and Mr. Stephen Arbuzak. And good afternoon to you all. Folks, I told you on Thursday that the trial begins with an opening instruction from me, so please listen up. Ladies and gentlemen of our jury, you have been selected and sworn as the jury to try the case of the state of Florida versus James Scandirito II. This is a criminal case. As you all know, Mr. Scandirito is charged with one count of first-degree murder and one count of abuse of a dead human body. The definition of the elements of those crimes will be explained to you later. The state's charging document, in this case, which is called an indictment, it's not evidence, and you are not to consider it by you as any proof of guilt. It is my responsibility as the judge to explain the laws to you. It is your solemn responsibility to determine if the state of Florida has proved its accusations beyond a reasonable doubt against Mr. Scandirito, in accordance with the law that I will provide to you at the end of the case. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make what is called an opening statement. As I told you on Thursday, an opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the course of the trial. What the lawyers say is not evidence, and you are not to consider it as such, but as I told you on Thursday, please listen closely. Each attorney is an officer of the court, and I know in good faith they will tell you what they believe the evidence will show during the course of the trial. Following the opening statements, witnesses will be called to testify under oath. They will then be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will then instruct you on the law applicable to Mr. Scandirito's case, and then the attorneys will give their final arguments. After the attorneys make their final arguments, then you will retire to consider your verdict. You should not form any definite or fixed opinions on the merits of this case until you have heard all of the evidence, the arguments of the attorneys, and the instructions on the law by the court. Until that time, you should not discuss this case amongst yourselves. Please always remember that your verdict must be based solely on the evidence or lack of evidence in the law. You may not communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify Deputy Ross, who will then advise me. During the course of the trial, the court will take recesses, during which time you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss this case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, tell that person that you are in the jury trying the case and ask them to stop. If that person persists, leave them immediately, report the matter to Deputy Ross, who will then advise me. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of Mr. Scandirito, the attorneys, and the court. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are here at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I need to stress to you all again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate about this case or your jury service. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. Folks, always remember that in every criminal proceeding, the defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their respective duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. Now, during the course of the trial, it may be necessary to confer with the attorneys outside of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. Folks, first, always remember that it is the duty and obligation of an attorney when they feel that a question that has been asked or that an answer that is sought to be given is in violation of the rules of evidence or trial procedure. In that case, the attorney is obligated to stand and make an objection. Don't ever hold it against an attorney that they make an objection. That's their job. Sometimes, well, I would say this, the opposite. 95% of the time, I will understand the objection and will be able to quickly rule on the objection from the bench. But sometimes I need further legal argument about the objection or the basis for it, and I will bring the attorneys up here to the bench, and I'll put on this obnoxious, forgive me for doing that, but what we do during that period of time is have some legal discussion. Remember, your bailiwick is the facts. I play no role in your resolution of disputed facts, and my bailiwick, so to speak, is the law, and you play no role in my decisions on legal matters. So if I need a little bit of an extended legal argument, I'll do that outside your earshot. I apologize for doing that during the trial proceeding. We're going to try to do as much legal work as we can in the morning before you come and in the evening after you leave. But sometimes during the course of the trial, it becomes necessary to do that. Don't ever hold it against an attorney or a side that they ask for a brief sidebar. That's what those are called, sidebars. That's just a regular part of every trial. It happens every time, and I have no reason to believe it won't happen here. But it won't happen that often, and when it does happen, it's just a natural part of the case. Don't ever hold it against anybody that they ask for a sidebar. Now, you have a notepad and a working government pen at your disposal to take notes if you choose to take notes. Now, we've had those pens fail in the past. So, please raise your hand, and Deputy Ross has a whole cache of pens over there waiting for you to substitute for the pen that has failed. So, folks, you've got your pad and your pen, and if you'd like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you don't want to take notes. The decision as to whether you should or shouldn't take notes is left up to each of you individually. You've got your notepad and pen for your use to take notes if you want. Any notes that you will take are for your own personal use. However, you can take them with you from the courtroom. So during recesses, Deputy Ross will instruct you to leave your notepads under your chairs. He'll collect them and return them to you when you reconvene. And then after you complete your deliberations, in this case, Deputy Ross will then collect your notes. He will then destroy them. No one will ever read your notes. If you do take notes, don't get so involved in the note-taking process that you become distracted from the proceedings. I want you to always remember that notes are not entitled, they're really to be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's respective memory of the evidence. With that, let me turn to the people of the state of Florida. Does the state wish to make an opening statement?
We do, Your Honor.
All right, Ms. Walters, you may proceed when you're ready.